All right, welcome to the Special Committee on Impeachment Inquiry, our first meeting this Tuesday, May 23rd. To start today, I thought that we would go around and introduce ourselves, even though we probably know each other a bit, but if we could each say which committees we've served on, how long we've been here, and what we represent. I'll start. Martin Malone. This is my fifth term on the Judiciary Committee, and this year I'm the chair of the Judiciary Committee, and I represent one of five representatives from South Burlington.
I'm Mike McCarthy. I represent the city of St. Albans, the Franklin 3 district. This is my fourth term. I'm currently serving as the chair of the House Government Operations and Military Affairs Committee, and I did a couple of terms on House Transportation before that.
Good morning, everyone. My name is Tom Burdett, representative from West Rutland. I represent West Rutland, Clarendon, Wallingford, and a big portion of Rutland town. I'm in my seventh term, which I can't believe, and my first 4 years were on Human Services, and the last 9 years I've been on House Judiciary, and I'm also the vice chair of House Judiciary.
My name is Carolyn Brannigan. I'm now halfway through my 10th term here in the State House. I served 9 terms and then took 4 years off, and I decided to come back. And I have served the first year that I was here, the first term I was here, I was on the Education Committee, which is my professional training. I was a grade school principal during my work life. But most of the time I've been on the Ways and Means Committee, which I enjoy very much. Formerly, I was vice chair.
And I'm Kelly Payala. I represent Londonderry, Andover, Weston, and Wen Hall. And I was appointed in 2017 and started serving on the House Human Services Committee then, and have been there ever since. And I'm also currently the chair of the House Discrimination Prevention.
I'm Karen Dolan, a representative from Essex Junction. I'm in my second term. This year I am in House Judiciary. Last year I was in Corrections and Institutions.
Matt Byron, Vice Chair of Government Operations and Military Affairs. This is my third term. I represent Northwest Addison County, Harrisburg, and Virgins, Waltham, Canton, Addison, and a portion of New Haven.
Thank you. So there's not really that much committee organization, and we're just going to be rushing and getting way ahead of this agenda today, but that's fine. We may not have to go well into the afternoon, but I wanted to make sure we had plenty of time. But just one point, usually in off-session committees like this, votes are usually taken by straw poll. But I feel that we're probably going to have some votes that we're going to want to have by roll call, and therefore would want to have a clerk. Unless there's an objection, I've talked to Kelly, who's agreed to take that position for us. Probably not going to be a bunch of roll calls, but I think we just have to be prepared. We have somebody identified for that. So with that, we're going to just jump ahead to 9:30 and look and have welcome Jen Carvey to review the resolution that set up the committee. Thank you for being here. Thank you.
Thank you.
Can you probably put it up on the screen and we all waiting for that, but I can.
People at home, maybe.
Yeah, let's go ahead and do that for those following along at home.
Just a moment to pull. I need to get myself into the.
We do have a committee page, right? So it's stuff posted on the committee page?
Yes, it is. Yes, it is. And actually on the first page of homepage, I guess we call it, of the Vermont General Assembly, there's an announcement and it's a link to that. Pretty easy to get to.
Quick document. You can see that. Great. Thank you for your patience. Good morning, Jen Harvey. I'm the Director and Chief Counsel of the Office of Legislative Counsel. I'll just let you know as well that there are members of my team here who are going to be working with you in the committee this summer. So this is H.R. 11, which is the House resolution establishing the special committee on impeachment inquiry and granting it investigatory powers. It was offered by the chair and vice chair of the special committee. So it starts out with two whereas clauses. Whereas the results of an independent investigation completed in April 2023 substantiated allegations that Franklin County State's Attorney John Lavoie has engaged in a pattern of harassment and discriminatory conduct toward his employees and others. And whereas recent concerns regarding financial improprieties in office have been raised regarding Franklin County Sheriff John Grismore, who was previously captured on video while a captain in Franklin County Sheriff's Department, kicking a handcuffed prisoner who was being held by the department. Now therefore be it resolved by the House of Representatives that the Special Committee on Impeachment Inquiry is established to investigate whether sufficient grounds exist for the House of Representatives to exercise its constitutional power to impeach Franklin County State's Attorney John Lavoie or Franklin County Sheriff John Grismore, or both. And be it further resolved that the special committee shall be composed of 7 members of the House of Representatives, not all from the same political party, who shall be appointed by the Speaker of the House. And be it further resolved that the special committee is authorized to meet during the 2023-2024 biennium, including during adjournment thereof, shall adopt rules of procedure and shall report to the House of Representatives such resolutions, articles of impeachment, or other recommendations as the special committee deems proper. And be it further resolved that the special committee is authorized to require, by subpoena or otherwise, the attendance and testimony of any person and the production of documents and other items of any kind. And be it further resolved that the special committee or any member so designated by the special committee may administer oaths or affirmations to any witness. And be it further resolved that the special committee may hire investigators and may request assistance from other governmental entities as needed to assist the special committee in conducting its investigations.
Thank you. So my understanding as well is that the Government Operations Committee passed this out unanimously 12-0, and there was a unanimous, at least I didn't hear any no votes, voice vote on the floor of the House that adopted this resolution. Are there any questions for Jen? I don't see any. That was quite straightforward. I appreciate it.
Sure.
So now we'll move to Betsy Ann Rask, the clerk of the House, to give us a high-level overview of the whole impeachment process. Thank you for being here.
Yeah. Good morning.
Good morning.
For the record, Betsy Ann Rask. I am clerk of the House. Just for background information, I was first elected in the 21-22 biennium, but prior to that, in 2010 and 2020, I served as an attorney in the Office of Legislative Counsel, which was related to government operations, which included general government structure, separation of powers, and election law. Being today specifically, as clerk for my legal practice is now focused on constitutional legislative procedure. And a specific part of that is helping the House and House members understand the scope of their legislative authority so that you can then determine how you want to exercise that authority in your role as elected representatives representing the members. So it was in that capacity that the Speaker asked that I draft a memo in regard to impeachment generally, which is a constitutional legislative function. And the Speaker allowed me to share that memo House members so that they can understand these general concepts of impeachment. Thank you to our Director of Legislative Operations for posting the documents that I provided. I'm also happy to be here for my colleagues in the Office of Legislative Counsel as they help me work through the constitutional process. Mr. Chair, does it make sense that I share a screen that memo so we can have a high-level walkthrough together of the documents and
Yeah, let's go ahead and do that.
if IT will cooperate with me, Director of Legislative Operations, thank you for helping me through this process, but let's see if I can actually execute it. I'm gonna try to. Yay, excellent, well, thank you.
Very smooth.
So this is a high-level overview of impeachment, just so you have this background information as you proceed. To summarize, our Constitution provides that state executive or judicial constitutional officers enjoy a term of office provided by our Constitution, and our founding document allows only one method of removal of such an officer. That's an impeachment ordered by the House and a subsequent impeachment conviction in the Senate. Our impeachment procedure is controlled by the Vermont Constitution, and the legislative branch then fills in the details as you perform this constitutional legislative function. It's rare in Vermont history. Impeachment, the last time that we've had an impeachment was in 1976, a recent occurrence. The 1976 House ordered the impeachment of Sheriff Malcolm Mayo, but there was an acquittal in the Senate. But thankfully, we have that to turn to as our most recent example of legislative impeachment. So this memo describes that impeachment is the sole method to remove an executive or constitutional officer. Because the state executive or judicial constitutional officer enjoys a constitutionally defined term of office, such an officer can only be removed from office pursuant to constitutional procedure. And impeachment is that constitutional procedure. This relates to a canon of constitutional construction called expressio unius, ex exclusione alterius, which means when the Constitution expresses that things will be done one way, that is the exclusive way of doing things, and it necessarily excludes any and all alternatives without having to describe what those alternatives may be. Impeachment is the way to remove a constitutional executive or judicial officer. Impeachment is specifically provided for in Chapter 2, Section 58 of our Vermont Constitution, which states that every officer of state, whether judicial or executive, shall be liable to be impeached by the House, and that the Senate has the sole power of deciding upon all impeachments. Our Supreme Court of Vermont has described impeachment proceedings as a constitutionally established procedure before the legislature, which has sole power in this respect. This comes from a case springing from that impeachment procedure from the 70s. This case was in regard to fees, legal fees in regards to that impeachment process, but it does provide some breadcrumbs of helpful information as well. So impeachment is for what our Constitution calls executive or judicial state criminals. This language comes from Chapter 2, Section 14 of our Vermont Constitution, which describes the powers of the House. It says that the House has the power to impeach state criminals. But our Constitution does not define what is a state criminal. It likely includes offenses made by the General Assembly to be crimes by statutory law. But because the General Assembly also has the exclusive constitutional authority to impeach, and because the Vermont Constitution does not define the term state criminal, it also seems possible that a constitutional officer may be impeached for conduct found by the General Assembly to violate public trust or to undermine the operation of government, even though that conduct is not specifically covered by criminal law. And this makes sense in our separation of powers in our Vermont Constitution. Pulling up the Constitution behind me online. Here's your impeachment language, the main impeachment provisions. But scrolling down to Chapter 2, Section 60, you'll see the legislature is actually restricted to declare anybody guilty of treason or felony, or to have a sentence upon conviction for felony committed or mitigated by the legislature. And in general terms, convicting somebody for a statutory crime is not the legislature's constitutional business. The separation of powers, the General Assembly's legislative branch legislates, enact laws, the executive branch executes those laws, and the judicial branch adjudicates challenges to it. It's the judicial branch's authority to hear cases where a person has been committed a criminal statutory law and to convict. And our Vermont Supreme Court has stated in one of its cases specifically that the General Assembly does not have the power to try persons for crimes. So it makes sense that you might not necessarily find that someone who should be subject to impeachment has committed a criminal statutory crime, because you're not in the constitutional business of determining guilt under statutory law. And this correlates to how impeachment is handled on the federal level. So for example, while the US and House and Senate in our federal government have authority to impeach federal civil officers for high crimes and misdemeanors, that's our language in the US Constitution. In practice, according to the Congressional Research Service, less than 1/3 of impeachments ordered by the US House have specifically cited criminal statute or used the term crime. So if you were to use this federal history as a guide, it may be possible for the General Assembly to impeach a constitutional officer for conduct such as improperly exceeding or abusing the powers of office, behaving in a manner that is incompatible with the function and purpose of the office, or misusing the office for an improper purpose or for personal gain. It's all, sorry.
Okay.
Sorry, are we asking questions?
Sure,
while we're going
absolutely,
through it?
yeah.
Okay. So thank you for this. And I know that you also gave this overview with House GovOps and Judiciary. So I appreciate hearing it again, because now I can pick up some things. This piece of behaving in a manner that is incompatible with the function, are those things defined, or is that part of what we'll need to do to say, like, this type of behavior is not compatible with it? Like, there isn't necessarily a book that says these types of activities are, so if you can help clarify that, that would be helpful.
That's great. So those terms that are used there in that paragraph are based on what has happened on the federal level and federal impeachments. And those are bases that the US House and Senate have determined are impeachable conduct for high crimes and misdemeanors under our US Constitution. I think you'll be delving further. You'll imagine spending a lot of time on what should constitute impeachable conduct, because it is a serious business.
Yes.
To remove someone from office who the voters have elected, but it is also your constitutional authority to do so as Vermont's elected representatives, representing the people and their interests. So these are huge issues that I anticipate this committee is going to be tussling with.
Great, thank you.
Just another question. So on the federal level, impeachment doesn't cause a person to be removed from office. I'm thinking of President Clinton. But at the state level, it will remove them from office?
Can remove someone from office.
Can.
Under our Constitution, Chapter 2, Section 58. There has to be a conviction. So essentially, we'll get more into this, but the House essentially acts as a prosecutor in a way to charge someone, order someone to be impeached. But the Senate acts as the judge in the case and determines whether to convict. And our Vermont Constitution says that judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold or enjoy any office of honor or profit of trust or trust under this state.
So does the Senate decision decide if they're in or out?
Yes.
Okay.
They issue the sentence. The Senate has the sole power of trying and deciding upon impeachment.
Thank you.
Picking up on exactly where you left off, Representative Brandon. It's clear from our constitutional language that an adjudication of criminal guilt by the judicial branch is not required prior to a legislative impeachment. That's because that language that we just reviewed in Chapter 2, Section 58 limits judgment in cases of impeachment to removal from office and disqualification to hold or enjoy any office of honor or profit or trust under the state. And it goes on to say, but the person convicted shall nevertheless be liable to subject to indictment, trial, judgment, and punishment according to law. So In other words, the penalty that the General Assembly can impose upon someone impeached state criminal is limited to restrictions on the ability to hold office. Impeachment does not limit subsequent criminal liability imposed by the judicial branch after an impeachment. And that maintains that separation of powers between the two branches. Because the judicial branch always has the power to convict. I'll just note here, along those lines, this is exclusively a legislative authority. This authority to impeach and say that a person is removed from their elected office and could be prohibited from holding office in the future is exclusively a legislative decision. Impeachment does not involve the governor like an act of legislation would. Actually, the governor's section of our Constitution, as our supreme executive officer, the governor's powers are set forth in Chapter 2, Section 20. The governor does have pardon authority, but that Chapter 2, Section 20 says that the governor is prohibited from granting a reprieve or pardon of impeachment pursuant to that section. The section goes on to provide that there is no remission or mitigation of an impeachment punishment except by act of legislation. So, in a hypothetical scenario, if there was an impeachment conviction and a removal from the person from office, the removal happens through that constitutional legislative impeachment procedure with the Senate trying and convicting. And the person who's removed from office could not in the future be allowed to hold office again except by act of legislation. So it would take another legislative act to undo that punishment. So the memo then goes into the general constitutional impeachment procedure by the language of our Constitution. The House begins impeachment proceedings by ordering an impeachment, which pursuant to Chapter 2, Section 57 requires a vote of 2/3 of its members. 2/3 of the members means the 150-member House. So therefore, at least 100 members of the House will need to vote in favor of impeachment. That's a high threshold. Compare it to, for example, even higher than veto, because veto is 2/3 of members present. This is 2/3 of members, so minimum. So once impeachment is ordered by the House, the proceedings then move to the Senate, which pursuant to Chapter 2, Section 58, has the sole power of trying and deciding on impeachments. The section provides that the Senate's power requires the concurrence of 2/3 of members present. So that's 2/3 of a quorum of the Senate. But assuming all 30 senators are there for an impeachment trial, that means a minimum of 20. Those members, 2/3 of members present in the Senate.
So it's 2/3 exactly, it's not like.
Or over,
Or over.
at least.
Right.
Yeah.
Yeah, Representative.
It's kind of maybe is going back a little bit. I'm just struck by this at the precedent that this is, so like, I think you're sharing this as you go through this, like the seriousness of this, because it sounds like regardless of where we go, even if we don't find it, like we're going to be considering what is behavior or actions that could lead to somebody being impeached. That this hasn't happened, I think you said, since 1976. And so we're kind of setting this, like, it looks like you've looked back through all of these pieces to see. So we're kind of setting that next point in history of this is where things are at and this is what could be considered impeachable, even if somebody doesn't get convicted or the Senate doesn't take it up. Is that correct? Like, I'm just trying to understand the full scope of this.
Anything you do, this is the furthest we've gotten since 1976. Anything you do now will be looked upon in the future as precedential value, but really it's up to you to determine in this moment whether you think there has been impeachable committed and then how you want to proceed. Recommendations.
Thanks.
Tina, I'm struck by something in the article that you cited, which was that there was confusion in the Senate trial of Sheriff Mayo back in 1976 about what the question they were trying to answer was. What were they voting on? Were they voting on whether each of the articles was actually an impeachable offense, or were they voting on the impeachment itself, or that the facts were true, I think is one of the things that was in that. And so at each stage that you described here, so we formed the special committee to consider whether articles are justified. At each stage here in the special committee, articles being considered before the House and then in a Senate trial, could you maybe elaborate or underscore some of what's in your memo for sort of what is the question that's being asked by each of those steps of this process?
So, big picture, I see you're an investigator. You are looking at evidence and you are going to be making a recommendation. The House is looking at you, looking to you to make a recommendation to the House on what action should be taken. So you're collecting evidence, you will collect evidence, you will review that evidence, and you will determine whether you think, based on that evidence, that impeachable conduct has been committed. It's going to be up to you through this process. The House is really looking at you to help develop this record. Whether you think this constitutes impeachable conduct meaning whether someone should be removed from elected office, and whether they should be prohibited from holding office in the future. We're going to make a recommendation to the House. And the House, you're going to have to be able, I think you should make a recommendation, whatever you decide. You make a recommendation to the House, and then the House determines whether a person should be ordered to be impeached, to take that next step. But the House agrees or thinks that there has been impeachable conduct, that person should be removed from office. The House thinks that by the 2/3 of the members. I think that is a security point in our Constitution, that it takes that vote threshold for 2/3 of the House members to come together to think that there has been impeachable conduct and someone should be ordered to be impeached. And then it's up to the Senate to decide, and I think where this will be for the Senate, I work exclusively for the House. Up to the Senate to decide, like a judge and jury would, whether conduct has been committed, that conduct should be. A lot of this, Mr. Vice Chair, it is a legislative decision. How you always have to make, it's a policy decision, in regard to our operation of state government. Impeachment is political in nature, means policy. You are the policy-making branch. You represent Vermonters. You represent Vermonters' interests. We elect you to be here to determine how our state should operate. And by decisions, this committee is making recommendations on what should happen in these cases. And the House will determine whether it should move forward to essentially charge in the trials, essentially. It's hard to capture because it is, that's why I always say that you all have a hard job, so making these tough policy decisions on what you think is right in this case for the operation of state government.
Good. Yeah, so it seems going forward, we're going to be balancing the policy or law on the one side and the facts, evidence on the other. And those are going to be working kind of together as we proceed. Policy or law is, well, what do we think is impeachable conduct? The facts and evidence is what actually happened in these offices. And it'll be developed. There's not a right answer at this point, certainly. And I think in part the evidence will be feeding into what we think is the appropriate policy and vice versa. So it should be fun. Should be very interesting.
Should be fun.
Maybe that's the wrong word. Interesting, though, is certainly, I think,
this is
balancing those two things.
Yes, it is is very interesting from a constitutional perspective. And you are conducting your you are exercising constitutional legislative authority in this regard. So this memo does describe, though, as the chambers proceed, that a person that is subject to impeachment should be afforded basic due process protections. So, for example, in the counterpart to impeachment for legislators, which is legislative expulsions, an Alabama district court vacated an Alabama state senator's expulsion in part because he did not receive adequate notice. There's not a formal charge made against him, and at the minimal hearing provided, he was not able to hear witnesses' testimony or cross-examine them. So the court there held that when a governmental body acts to injure an individual, the Constitution requires that the act be consonant with due process of law, because Constitution always controls and Constitution requires due process. So there has to be basic due process protections built into the impeachment process. Generally, your attorneys in the Office of Legislative Counsel have been analyzing for this committee as you proceed to determine what overall impeachment procedure could look like.
Representative Dole.
Sorry. I feel like this is the time though to ask all these questions, right?
No, absolutely.
So with the due process piece of it, so like this is a team that we're going to be monitoring and making sure all those pieces are in there. When the person that is on the other side of this and is feeling like they're not getting the due process, what are the points for them to like say something like I'm not getting it, or is it at the end, or like how will we know? Because I think we want this checks and balance, or is it just we wait till the end and do they think they got due process or not? Like, can you share about that a bit more? Because I feel like that's important for us to be checking in and making sure we're doing everything.
Overall, I liken it to you acting essentially as an investigative team now, as you described. So you are building a case like prosecutors and an investigative team would build a case and determine whether to move forward with charges. I think ultimately the main due process protections, it's during the conviction, the Senate trial. I think you can accept contents, of course, anywhere along the way for what is appropriate. You just have to weigh that as it comes and kind of have a clear picture about what everybody's roles are. This is an investigative committee, though, generally speaking. So you are investigating at this point. And the House essentially acts as the prosecutors and determine whether to charge or order somebody with impeachment. But the main the trial of the person at least has that ability to have those, especially there, the due process protections during the trial.
Okay, and I guess maybe this is me not fully knowing due process either. Like, is it saying like we didn't get certain information or we didn't get the full picture of stuff, or that can also come out in the trial part of it as well too. What we investigate is not the whole sum of it. We're investigating to make our decision of do we move forward. It's not the only information that can then be used in the trial conviction piece of it, right?
Generally, that sounds correct. I want to ensure that I know the observations so I know this will be addressed later. So I think more details we can discuss later. The final thing that on this page is that Chapter 2, Section 58 of our Vermont Constitution provides that an executive or judicial officer of the state may be impeached either when in office or after resignation or removal for maladministration is the language. So the ability to impeach after an officer has resigned is likely considered a measure of accountability, so that even if a person tried to escape culpability by resigning, the General Assembly would still impeach the officer in order to disqualify them from holding another office in the state if that was what is felt was appropriate, because remember, judgment in cases of impeachment extends to removal from office or disqualification of hold future ones. When it refers to the separate ability to remove for maladministration, a separate process to remove, that seems like it is outdated language from our original 1777 Vermont Constitution. I have it up behind me. A way to search for this language is, so we're on our third Constitution. 1777 was our first one, then 1786, and then our third one was 1793. We're operating under our 1793 with articles of amendment there too. Our original 1777 Vermont Constitution provided for our, not all of them that we have now, but our statewide executive officers, which at that time was the governor, lieutenant governor, treasurer, and executive council. We also had a council of censors. But then the general also provided were elected county officers that were elected by voters of each county. And our original 1777 Vermont Constitution did say, here it is behind me, section 20, every officer of state, whether judicial or executive, shall be liable to be impeached by the General Assembly, either when in office or after his resignation or removal from maladministration. And says that impeachments at that time were before the governor and or lieutenant governor and executive council. Because at that time, that was before we had a Senate. We didn't get a Senate until 1836. But then if you search, the way to search for this is to search for maladministration. The second ability to remove an officer under our 1777 Vermont Constitution was for those elected county officers, where this section 27 provides that there shall be county elections. The judge to elect where the voters, the freemen of each county were able to elect judges of Court of Common Pleas, sheriffs, justice of the peace, or justice of the peace county officer, probate judges, removable by the General Assembly upon proof of maladministration. So there, the General Assembly alone, acting unicamerally and unilaterally, had the ability to remove county officers. And then the Constitution provided in those two places that those county officers could then be impeached, separately impeached, before the governor and council. But in our 1786 Vermont Constitution, that separate authority to remove those county officers was deleted. And at that time, the county officers in our 1786 Constitution were elected by the legislature and the executive council. Big picture, that separate authority to remove those county officers was removed by our 1786 Constitution, but reference to that separate removal authority still appears in our current day Vermont Constitution, likely because it's just so difficult, it should be, to amend our Vermont Constitution. I said we're operating under our 1793 Constitution. Right now we're under a 4-year time block to amend our Constitution. It's a rigorous process, rightfully so. Our current document, we used to up until the 1960s. We had to amend our Constitution, we were under a 10-year time block. So, according to NCSL, I think around 8,600 words of the Vermont Constitution is the shortest in the nation, likely because it's so difficult, rightfully so, to amend our Vermont Constitution. So things like this still appear in our Vermont Constitution. Separate authority to remove does not appear applicable anymore. Impeachment is the sole method to remove.
So before you go on, we shouldn't read too much into the word maladministration that is in section 58, because it seems to be a holdover from an earlier time, the earlier constitution that allowed removal by the governor for maladministration.
I can't say with certainty because the Vermont Supreme Court is the final interpreter of the Vermont Constitution. Our impeachment is case law is so spare. It doesn't appear, it appears connected to that removal, that separate removal authority, but I don't know with certainty. I can't tell you with certainty. Big picture, administration may be at least something that you decide is appropriate for impeachment, but couldn't tell you with certainty today sitting here.
So it's not certain that the Constitution requires it or doesn't require it, but there's no reason why we can't adopt maladministration as part of a standard, like they did in the 1976 impeachment.
Yes.
All right, thank you.
Betsy, in the 1976 case, there was a motion to dismiss. And there was some question about the authority of the General Assembly to impeach a county officer. And it seems like the Constitution in its previous iterations was really clear on this. And the Supreme Court seemed pretty clear But do you have any color, or could you summarize that for the committee? Because I don't know if everybody's read the document that has the journal record from the Senate in 1976 that the clerk provided for us, but it was interesting how that was presented. And then it seems like in the journal, they just sort of proceeded. So what does that motion to dismiss really mean, and how can it inform our understanding of what our power is over county officers?
I don't think that there is a question that how county constitutional officers are an executive officer, judicial officer. In fact, our Vermont Constitution right now doesn't say that our state's attorneys and sheriffs are county officers, because the Constitution says that the General Assembly establishes their districts theoretically, because there's plural sheriffs and state's attorneys in our Constitution. There just needs to be more than one of those officers. The General Assembly is established by statute that our state's attorneys and sheriffs are elected along county lines. And also, when we refer to executive and judicial officers, you can see our Vermont Constitution is separated into legislative, executive, and judicial departments. Legislative, executive, and you'll see sheriffs are mentioned here. Judicial, they have to fit somewhere. They are executive officers, state's attorneys and sheriffs are executive officers. There hasn't been a question raised in for example, in the Mayo case from Vermont Supreme Court, that they are executive officers that can be subject to impeachment. Otherwise, there would be no method to remove those officers if necessary.
Thanks.
In my mind. So I will just move on now to the last part of this memo, which is potential specific legislative impeachment procedure. It starts by providing a link to the Secretary of State's webpage on the history of impeachment in Vermont.
I'm sorry, I apologize. Just a question just came up before you get to that next step. So on that issue of the dismissal and what our Constitution provides, is the final arbiter of that our Supreme Court? I mean, if somebody disagreed with that, disagreed or thought that sheriffs or state's attorneys were not subject to impeachment under our Constitution?
Yes, I would say yes. The Vermont Supreme Court is always the final interpreter of the Vermont Constitution. Any case law we can get, all along TV, except maybe. Vermont Supreme Court is the final interpreter of the Vermont Constitution. They don't have the final say.
So anything we are doing here, not anything, there may be areas that the Supreme Court can't touch, but interpreting the Constitution, like the reach of impeachment, is something that could be open.
Sure.
For challenging.
Yes. I think big picture, there's a principle in constitutional construction called political question doctrine. Essentially, it's going back to that when the Constitution says that one entity holds the authority to do something, that entity is the only entity with the authority to execute that authority and cannot be judged judicially. For example, in each legislative chamber's authority to judge their member qualifications, to discipline members, our Vermont Supreme Court in our 315 case has said that when the Constitution provides that ability to judge member qualifications to each chamber of the General Assembly, that chamber has the exclusive authority to do that, and any attempt to weigh in on that would violate separation of powers. Political question doctrine. Our Vermont Constitution provides authority to one entity, that's the only entity that has it. Our Vermont Supreme Court has already called impeachment the sole power of the legislature. So when it comes to questions of whether a person should be impeached, all of our constitutional construction case law that we have, the limited Vermont Supreme Court case law on impeachment, all points in the direction of the legislature is the final authority on whether someone should be impeached. But questions about whether any constitutional provisions apply, like due process, because due process is a constitutional right. Or constitutional questions about scope. Those questions can always come before the Vermont Supreme Court able to adjudicate these challenges. And we always turn to the multiple court for guidance on what our Constitution says and means because they are our final interpreter.
Good, thank you.
So going into the potential specific legislative impeachment procedure, again, just to reiterate, we have so few examples. The last time happening in 1976, where the House ordered the impeachment of a sheriff, the sheriff was acquitted in the Senate. Before that, when a person was both impeached and convicted, the last time that happened was apparently in 1785. So that's a year before we got our second constitution. We were a unicameral legislature at that point, with impeachments happening before the executive council and government. So not a lot to go on, but we can turn to the 1976 impeachment proceedings of that sheriff, which were based on the following allegations: falsification of reports and documents, failure to perform the function of an office, and breach of duty as a peace officer. So based on that example that we have, here is an outline of specific legislative procedure that could be used based on that recent history, with references to the 1976 House and Senate journals, which our director has posted on your legislative webpage. So you're already partway through this process, making history as you go. The House has voted on a House resolution authorizing a named House committee to investigate allegations, providing it subpoena power, that's subpoena power by that resolution, and to make a recommendation on whether to impeach. And this is what this committee was going to do, this special committee of the House. So if you want to have a reference for the time that it took, I've also provided the dates that each of these things happened. So, for example, in 1976, this House resolution was adopted January 16th of 1976, and that resolution is posted online. And Director and Chief Counsel just happened to point out to me last time it was also HR 11. Just coincidence. So then the House committee investigates, and that's where you're having this process to determine your process of moving forward on any investigation. Ultimately, you're going to make a recommendation. I suggest you do so no matter what the outcome of this process is. You make a recommendation to the House. If you recommend impeachment, ultimately, members of the committee could introduce a House resolution that sets forth articles of impeachment. So remember, House resolution is offered to the House to vote on. Using this 1976 prior practice, this resolution set out articles of impeachment, essentially charges for the House's consideration on whether to adopt. It is like any other legislative process where there can be amendments recommended to amend some of the language, for example, or to change or to strike articles of impeachment. So, and that is set forth being ultimately the resolution back in 1976 is provided on your website.
Before you Representative Dolan.
Yes, so I heard you say that you recommend us making a recommendation either way. So I'm interpreting that as recommending articles of impeachment or specifically not recommending articles of impeachment. And wondering if you can share more of why that would be. Because I'm guessing we have the option of just saying we found nothing and we just dissolve ourselves. But can you,
sure. Yeah. And I would think that that would be in the form of a report because you're not proposing any House action. And the reason is because that's what you were formed to do. And I think the Director and Chief Counsel has reviewed with you. I think that the language provides that you would provide recommendations back to the Director.
okay.
It does say that resolved last year shall report to the House such resolutions, articles of impeachment, or other recommendations as you deem proper. But a big picture, the House will want to know what the outcome of your work was. So, for example, if you did not recommend impeachment, I would think that this could be in the form of a report to the House that this is what this committee did, and ultimately this is what we considered, and ultimately our recommendation is not to for example. But if you did want to pursue, you thought that it was appropriate to pursue impeachment, then a resolution, that House resolution, setting forth articles of impeachment could be introduced for the House's consideration. The the ability to amend and ultimately vote on a final version like you would on legislation, any other form of legislation.
May I ask a follow-up question? I'm just kind of thinking how it would go through. I feel like we as a group will do our due diligence and come up with firm recommendations of it. But say we did go with, we don't believe there is enough for impeachment, and we bring that report to the House floor, is that up for like, that can be discussion and like debatable? I don't know what the
A
word is.
report, no, because it's not recommending legislative action.
Okay.
But anybody could introduce an impeachment resolution, any House member.
Okay.
Ultimately, it's up to the House to decide whether it wants to adopt that. So let's say you got the point that this committee would recommend impeachment, and would set forth articles of impeachment in that House resolution, the House would need to vote on it. Again, just to emphasize, in order to impeach, charge, the House must adopt the resolution by at least 2/3 of its members, so at least 100 members would need to adopt that resolution. So for a timeline reference, in 1976, the House adopted those articles of impeachment on March 10th, 1976. So then, this is not provided for in the Vermont Constitution, but what the standard legislative practice is, and what happened in 1976, is that there would be House impeachment managers. When the Speaker would appoint, last example was 3 House members to be impeachment managers, who essentially act as prosecutors for trial in the Senate. And that was provided for in those articles of impeachment, and then the Speaker subsequently appointed those 3 impeachment managers. Then, so if the House ordered impeachment, perform that constitutional function, order impeachment, the trial then is held in the Senate. The Senate would need to adopt rules for the impeachment trial. Again, this would be a Senate decision here in 1976 on March 25th. The Senate adopted rules for the impeachment trial, quite detailed, but that would be up to the Senate to determine what, if it got to that point, what would be appropriate for them for rules of their impeachment trial. That's a Senate decision.
Anything else?
Is the Senate automatically obligated to move forward with a trial if we order?
That's a great question. I don't want to speak for the Senate.
Nobody would.
Attempt to do that. I don't think that they would be forced to do that. I'm going to leave that up to the Senate to decide. That is their decision. I don't think the Constitution.
But it is a decision, it's not an automatic move forward.
I don't want to say with certainty at this point as that House is
Representative Dole?
That was gonna be my question. I think that's an important piece of this, you know, like we need to do our work, and it's interesting just to think, where would it go from there? So appreciate the question.
If there is an impeachment trial in the Senate, House managers would act as prosecutors, present evidence, call witnesses, persons subject to impeachment, may be represented by their own counsel, cross-examine witnesses, present their own evidence. And that Senate threshold is 2/3 of members present, but assuming all members are present in the Senate, that would be at least 20. That's 2/3 of a quorum in the Senate. So for reference, in 1976, the Senate trial began on May 17th and ended on June 2nd. So wrapping up, executive judicial constitutional office terminally removes from office pursuant to impeachment ordered by the House, subsequent conviction by the Senate. Impeachment is for state criminals, someone would be labeled a state criminal. That likely includes statutory crimes, but it can also include conduct not covered by statutory criminal law. And Constitution always controls, so you must act according to the constitutional vote requirements and afford basic due process protections. So I'm subject to.
Other questions? don't see any. Just one other question. So for criminal indictments, criminal law, one needs to know what is forbidden in advance. You need to know that a certain behavior could lead to criminal liability. That's not the same for impeachment, as my understanding. Is that correct? I mean, that.
Yes, they, it's always an authority that the legislature holds.
When you say yes, they do, I mean, do we?
An executive judicial officer is always subject to impeachment. It's a constitutional authority that the legislative branch holds.
Right, but my point, I guess, is that we can find behavior that has occurred that may not be a criminal offense. And because we haven't done an impeachment in over 50 years, there's not a lot of guidance of what may or may not constitute maladministration. But we can look at what the behavior is and say that is impeachable conduct. It doesn't, in other words, there isn't a notice to somebody subject to impeachment that what they're doing may be an impeachable offense.
Yep.
Did that make sense? Yeah.
That's because ultimately you're acting on behalf of someone else. You are expressing good owner's interest through in your legislative capacity.
We're judging whether the public trust has been breached and whether it may be breached going forward as well. Looking at a very high level.
Yes, that's a great way to describe it. The job is maintaining the integrity of the Vermont state government.
Go ahead. Do you want to talk about this idea further of the definition of a state criminal with Betsy Ann, or is that something we should really talk about with legislative council?
I think, yeah, we're going to get into that more deeply, probably at the next meeting. And yeah, so we're not going to necessarily get into it more deeply at this point. And it'll probably be legislative council, I assume, or whoever is going to be providing us that guidance going forward. So, any other questions? Not seeing any. Thank you so much. And we'll take a 10-minute break before we then dive deeply into our draft procedures and rules. And Mike, I will distribute a hard copy of those.